Alright, good morning, you guys. So, if you're watching this, that means that you have already done the warm-up, which was just a Google Meet, take attendance and check in with you guys. I had originally planned to do these notes live, but I don't think that would be smart regarding how I'm feeling. So, today we're going to talk about constitutional rights before a trial takes place, and then the question that we're going to be really looking into is how does the Constitution specifically protect its citizens before a trial. So one of the things that we have to understand before we start talking about your rights before a trial is the fact that Americans as a whole value their privacy very much. They want to be left alone. I don't want to be snooped or spied on by the government. I expect to be secure in my home from the police. Okay. Now, Americans value their privacy so much, including our founding fathers, that they somewhat put it in the Bill of Rights in the Constitution. Okay. And that is in the form of the Fourth Amendment. So the Fourth Amendment protects Americans specifically from unreasonable government searches and seizures. Now, the police need evidence to investigate and prosecute crimes, but getting evidence will often require them to search, people, homes, cars, offices, maybe their electronic records. Now, the Fourth Amendment is not absolute in that it doesn't mean that the government can't ever invade your privacy to look for evidence of a crime. It does mean, however, that government cannot engage in unreasonable searches. So, what do the police need to do? Well, oftentimes they're going to need to obtain what we call a search warrant before they can make a search. Now, a search warrant, it's just an order that's signed by a judge. And what it does is it will describe a specific place that the police want to search, and then also for specific items. Okay. Now, there are circumstances or situations, where a warrant is not required to search. Okay. One of the examples or situations where they don't need a search warrant to do a search, okay, is if, an item is in plain sight. So let's say that you are stopped by a police officer while driving your car, and as the police officer is walking up to your car, they notice a massive bag of, weed in your back seat, okay? They do not need a search warrant to seize that item because it is in plain view for the officer to see. Another example where a search warrant is not needed is the police are allowed to search a person or their belongings if the person voluntarily consents to the search. So, let's say the police come knocking on your door and they say, "Hello, we've had a string of drug issues in this neighborhood, and we were wondering if we could just take a look around your house." If you consent to that search, if they find anything, legally you can be held responsible to it. Okay. Now, one of the final situations, and we're going to hit this heavy in our reading today, is that searches in public schools are very, very different from normal life. And school officials do not need warrants or probable cause to search you guys or the property of the school. For example, your wallets. Or not your wallets, your lockers. Man. Alright. Now, arrests are also considered a seizure. Because remember, the Fourth Amendment protects from unreasonable searches and seizures. And so, under the Fourth Amendment, we classify arrests as a seizure. Now, an arrest takes place, obviously, when a person is suspected of a crime. They're taken into custody. And then a person can be arrested under a couple of different circumstances. The first one is just simply under a warrant issued by a judge. Okay. Now the other one is if law enforcement has probable cause, meaning that they just have reasonable belief that you have committed a crime. Okay, so let's say you are arrested. Alright, let's say you are arrested. Now after that arrest is made, it's standard police practice then to question or interrogate you. Okay, and we've probably seen this all in TV shows, you know, the good cop, bad cop kind of thing. Now, these interrogations might result in a confession that can be later used in court. Now, remember, the Fifth Amendment protects people from self-incrimination, meaning that you do not have to testify against yourself. And then the Sixth Amendment ensures the right to an attorney. So police have to balance really their interest in gathering information and also, you know, your constitutional rights. So a confession can't be used in court if it's not voluntary. Like they can't, you know, torture you. They can't use physical force or threats against you. That is prohibited. Now the other thing that we're going to hit on heavy is your Miranda rights. So the Supreme Court ruled in Miranda v. Arizona, which happened with this gentleman right here in 1966, that the Fifth Amendment requires police to inform a suspect who's been taken into custody of their rights before they can question them. Okay, and those rights, you know, you have the right to remain silent. Any statement can be used as evidence against you, and you have the right to an attorney, and if you can't afford one, one will be provided for you. All right. And then if you're taken into custody, like if you are arrested, and if you are not informed of your rights, a statement that you make cannot be used in court. However, you know, if the police just come knocking on your door and say, hey, do you know anything about this? And then you confess to that, they can use that against you because you weren't arrested, you weren't taken into custody. And therefore, they didn't have to read you your Miranda rights. Alright guys, so the next part of our lesson is the crash course for this video. And you can send me an email if you have any questions. And I will hopefully see you soon. Bye.